should have said for long silence. All rise. Hear ye, hear ye. Court of Appeals for the First District session. Salute to the Cone, God save the Constitution and the Son of the Court.
Thank you. Please be seated. Good afternoon. Welcome to the First Court of Appeals. Today we have myself, Justice Amy Guerra, Justice David Gunn, and Justice Susanna Docupil. I'm serving as panel chief today, and we have one case on the docket this afternoon. It is case number 01-2300825, ASTRA Ventures LLC versus Service Steel Warehouse Co. LP. May we please have announcements beginning with the appellant.
Good afternoon, Justice Paul Pelosian here for the appellant, ASTRA Ventures LLC.
Good afternoon, Justice MISTY HATAWAY-CONE on behalf of APPELLEE Service Steel.
Thank you. Each side will have 20 minutes for argument. Does appellant wish to reserve any time for rebuttal?
Yes, 5 minutes, please.
5 minutes reserved. Very good. Before we begin, I'm sure you all are familiar, but you know the lights are for green means continue, yellow means we have 1 minute left, and red means stop. If you're in the middle of answering a question from the panel, then feel free to continue. And if for some reason we have you go far over your allotted time, we'll make sure to even that out with the other side to make it as fair as possible. And so we obviously are familiar with the case. We've read your materials, so feel free to not go through the background and just jump into the legal issues. With that said, we are now ready to proceed and hear from counsel for appellant.
Thank you. May it please the court. I'm going to just jump into the issues that the court identified in the notice letter that we received last week. The first issue is that the trial court concluded as a matter of law that my client had waived the right to challenge whether or not the lien was perfected properly because the court found that we had not sufficiently pled or denied conditions precedent. And the court, first of all, that's a de novo review by this court since that was the conclusion of law, or at least that's our position. If you look at the exhibits, I put our answer in the exhibits, and the first exhibit is the answer, and I tried to pick out sections 14 through 17, although I didn't get your all's notice letter. I know you sent it before, but I didn't see it with the topic, so I didn't include all of the affirmative defenses that were raised. But I think the key here is that we're notice pleading, right? And so it doesn't require technical language or anything like that. It just has to provide fair notice of what we're asking or what we're claiming. And if you look at paragraph 14 and 15, you can see from these paragraphs that our main complaint with the lien and the notices and the claim in general was that the person identified as the customer of Service Steel was Ipsum Building Supplies, somebody that we had no idea who that was, and not our contractor. And so that's, the court said that wasn't sufficient. The court just said, no, it doesn't say conditions precedent. And there's a Texas case on that. It's TABE, and it's from this court from 2018, TABE versus Texas Inpatient Consultants, LLP, which is cited in our brief, but it's 555 Southwest 3D at 382. And basically, this case was an employment contract between a doctor and a hospitalist group. And in the employment agreement, it said, well, if the doctor left within a year of employment, then he had to pay back a certain amount of sum in liquidated damages. And the doctor did not, in his answer, plead any conditions precedent, didn't put anything in there. But in his response to a summary judgment, he said that basically, hey, this contract didn't start yet because a condition precedent, or he didn't say condition precedent, but the contract says it'll start once you credentialize me. And it was your obligation to credentialize me, and you hadn't completed that. And I quit before I was credentialized, so the contract hadn't started yet. And this court said that was good enough. There was no magic language that was required. Fair notice pleading, you understood what his claim was. And even though it wasn't contained in the answer, the court said because it was in a summary judgment response, and in fact, it wasn't even in a response, he just filed an affidavit. He didn't file a response at all except the affidavit, which the court also said was okay.
Court did say that. It doesn't make any sense to me. It doesn't seem to me consistent with the rules, but I take your point. I'm wondering, perhaps the rationale there is that the parties have essentially tried the issue by consent?
I think the issue, again, in being a trial lawyer myself, the issue is, are we surprised by this? Have you told me what the basis for your claims are? And whether it's in because if you look at the rules of civil procedure, that's really how they operate, right? The disclosure rules or discovery rules say you have to supplement unless the information has been made known through some other pleading, right? And so this is the same sort of thing. I'm not ambushing you here. We've been arguing this for the last 2 years.
And I have a question about that. Tell me, assume there were no pleadings, just hypothetically.
Right.
But make your case for why you had been fighting about this for 2 years, and tell me whether or what in this trial would bear on the question whether you tried it by consent.
Sure. So if you look at Exhibit 2, that is the response to the first summary judgment that was filed by Service Steel. And if you look at page 191 of the record, again, the exact same defenses that were included in the answer are included here. And if you look at 192, it says plaintiff's petition, lien, and claims suffer from a simple but fatal defect. Plaintiff, by its own admission, blah, 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 contracted with somebody who we didn't contract with.
You're
right?
talking about 192 of the clerk's record?
Of the clerk's record, yes.
Tell me about the trial. What happened in trial? Did you fight about this at trial?
Well, so I wasn't the trial lawyer, but it was fought about at trial. There was a lot of evidence put on about who Ipsum Building Supplies was, about whether or not we knew who they were, whether or not it was included in the lien. In fact, the court made specific findings and conclusions based on the fact that it found that we knew who Ipsum Building Supplies was, even though there was no evidence of that. They put into the record the assumed name certificates. We put in the record assumed name certificates. We put in the record the Texas Comptroller's document showing that the contractor that we contracted with, which was, excuse me, I'm going to get it, Rush Steel Fabricators, actually is a company that had filed, it was an LLC. The name Ipsum Building Supplies, which is the name that Service Steel had for its customer, was a DBA of another gentleman by the name of Ruben Mercado, not Robert Gonzalez, who is the owner of the company that we dealt with.
Oh, let me ask you a further question about that.
Yes.
How do you deal with the emails that were in the record where it seems that ASTRA acknowledged that Ipsum and Rush Steel were DBAs of each other?
So, in two different contexts. And the way to think about this is that Service Steel does not have a direct claim against my client, right? They are a materialman. They have no contractual relationship. The only way that they recover is by compliance with the lien statutes. And so the question is, at the time they sent that link, their notices, did we know? And I think those emails you're talking about came after the fact. And the reason why that's important is the way that they're trying to get at us is for failure to track funds and failure to retain. And the notice periods of that, we didn't know at the time that Ipsum Building Supplies was the same as Rush Steel Fabricators, the people that we were dealing with. In fact, Rush Steel Fabricators, Inc. filed a lien, and then it put it in the exhibits, I believe it's exhibit number 11, claiming that it was owed $123,000. It didn't identify itself as Ipsum Building Supplies or Ipsum. And the other thing about that that I think is important to understand is at the trial, the representative from Service Steel testified that the basis for their account, all their information, what they came up with was based on a customer information sheet that was filled out by their customer. And that document is also one of the exhibits that I attached, and it is exhibit number, I think it's exhibit number 7. And the customer identified themselves as Rush Steel Fabricators. Now it does say DBA Ipsum, but that's how they identified themselves. But they didn't put that on their lien notice to us. They said their client was Ipsum Building Supplies. And so when you're trying to say,
even if you're technically correct, it seems that ASTRA was on notice that this alternate name was used. So is there really any unfair surprise?
There is, Judge, because Justice Dokapol, because this is another problem. This case has so many issues. It's very hard to focus on just one of them. But the way that we're liable under the statute is, okay, they send a notice out on May 15th, 2017, saying we're owed $11,000 and some change. Under the statute, if we pay our contractor after that fact, right, instead of holding that money to pay that claim, well then we're liable to the material men for that amount that we didn't withhold, right? So they send a notice May 15th. They don't actually send it to my client. They send it to OFT, who is we believe is the sham contractor, basically the general contracting arm of my client. OFT doesn't even get it, right? The record shows that it was returned undeliverable or something. But let's just assume they did get it. At that time, those emails that you're talking about, they post-date that. The only payment we made to this contractor was May 17th. The only payment we made after that first notice was written was May 17th, 2017. I'm sorry, I think it's actually May 19th. But it was a couple days after that notice. Assume we got the notice and it says Ipsum Building Supplies. We don't know who Ipsum Building Supplies is. They're not somebody that we contracted with. So we were prejudiced by that fact, right? We're prejudiced by the fact that saying, hey, this person who we don't know who they are owes us money. And the question is, under the statute, does that require us to trap those funds when it's not our subcontractor? Even though it may be our subcontractor, but the notice doesn't provide the notice that it is. And the other thing that's interesting about it is the address they used in their notice letter for Ipsum Building Supplies was a P.O. box, not the address that they were sending their invoices to, which is the address that we had. That might have tipped us off that, okay, well, this is Rush Steel. This is who they're talking about.
So I have a question,
Yes.
sort of as a practical matter. I think I recall seeing some testimony from the trial from your client that he's saying, well, I've got these sort of notices, and what do you do when you don't know what to do? And it made me wonder, okay, if you don't know what to do and you have these, what he seemed to think were almost competing notices or issues and didn't know to whom he should pay any money, why doesn't he get on the phone and call people and try to run this down and figure out what's really going on here?
Right, and I think he testified that he did try to get in contact with Robert Gonzalez, and he couldn't. He was in contact with Service Steel, but he was not able to get in contact with Rush Steel. But one of the problems with this case is Robert Gonzalez, Rush Steel, they abandoned this job, right? And so, I think the trial court even mentioned this during the trial, that this is a case where neither side's at fault here, right? I mean, we didn't do anything wrong. Service Steel, if it did anything wrong, it would be that it continued to sell steel to somebody who wasn't paying them, and they're trying to hit us with a bill, right? That's what happened here. They delivered about $35,000 worth of steel. We paid Rush Steel for that steel, and after that, they delivered another $50,000 worth of steel.
Okay, question.
Yeah.
What, the LTF case, what do you take out of that?
So what's really important about that case is that the name of the contractor to whom the supplier provided the goods is an essential element of the lien, right? Substantial compliance isn't good enough. It's an essential element. And they said that because you omitted it in your lien's invalid. Regardless of whether or not in your pre-lien notices that you sent to the owner or the contractor that you identified the person that you provided the goods to. Doesn't matter, because it's an essential element. So then the question becomes, well, what if they give the wrong name, right, as happened here? They didn't omit it, but they gave the wrong name. Well, if it's an essential element, I would argue that it's the same thing, right? If you give me a name that isn't even close to the person's name that I dealt with, it wasn't like they said Rush Steel Inc. instead of LLC. They gave us a name that was a completely different name.
Okay.
And so that's our argument there. That, and two, assuming substantial compliance is good enough, the testimony of my client that we were prejudiced by this because we didn't know who this person was. We were getting a lien from Rush Steel. And again, this all goes back to retainage and things, and I want to get into that. Your questions are completely valid, and that goes to the underlying lien itself, whether on its face it's valid. But we think that the amounts in that lien are completely out of line of what the law is.
So, well, on retainage and trapping, just briefly, what's the decision tree? I mean, if you lose, just hypothetically, on retainage, would we reach the trapping question?
You would, because the only way that the problem with this judgment is the judge held my client individually liable for $83,000.
Right.
Plus prejudgment interest of 18% based on a contract that my client wasn't a party to. Okay. The only way that the owner is liable personally is under the trapping statute. And the most that we could be liable under the trapping statute is $11,000, I think it's $387, something like that, which is the amount that we were notified before we made the last payment to Rush Steel, right? We paid them $17,000 on the 19th, I believe. Their notice letter is dated the 15th. We didn't get it, but assuming we did, if you guys were to ignore that fact, then that was the amount they were claiming. That's the amount that we were supposed to trap. Under retainage, your only remedy is a lien. You don't get a judgment against the owner for the amount that they were supposed to retain, because the statutes are written differently. And that's the case that we cited in our brief. I believe it's out of Austin. But it's the only case on this issue. And it is Precision Roofing versus, and I'll have to spell it, ZAVELSON. And the Westlaw site is 2018 Westlaw 5852680.
So you mentioned prejudgment interest. I have a question about that.
Yes.
I'll just tell you where I start conceptually is with Johnson and Higgins against Kinnico from the late 1990s. That sort of says, okay, we have a statute that covers, what is it, wrongful death, personal injury, property damage. And the court says, for other areas, we want the common law to conform to the statute. And even if it's just a pure economic damage case, it's not wrongful death. And so that the old Kavanaugh scheme, right, they adjust it. So that's where I start when I come to an interest problem. I think, okay, Johnson Higgins sort of fills the area, which suggests to me some kind of interest ought to run here, but I want you to have a shot at it. So give me your argument. I take you're going to say something like this is all just the lien statutes and that's all you get?
Well, so there's two different things going on here. One is the lien itself. The amount of the lien, it is absolutely clear under the law that you cannot include prejudgment interest or interest at all in the lien. The question is whether you can come after me for prejudgment interest on the underlying debt if I'm not liable for the debt. So the first argument is, well, we're not liable for $83,000. If anything, we're liable for $11,387. So yes, arguably you could say that you're entitled to prejudgment interest, but it's not 18%, right? It would be 6%. Or
why 6?
Or not 6, I'm sorry, the 8, whatever
it is today,
yeah,
the floating rate.
I can't remember what it is off the top of my head, but
the one that the credit commissioner publishes
correct.
Every month.
Correct. Yeah, in a contract case, if there's not one stated in the contract, then it's 6%, but otherwise it's the same as the post-judgment interest rate. I'm out of time here. I don't know if you want me to keep going. I can handle the rest of the rebuttal.
If you don't mind just touching on the other questions briefly that we sent to you.
Yes, sure. So sham contractor we haven't really talked about. That one's kind of twofold. One, and I'm assuming you're familiar with the statute. Basically, the statute says you elevate a subcontractor to an original contractor if the original contractor is controlled by the same people who control the owner. And in this case, it was pretty much undisputed that was the case. My client, Attila Tuna, well, my principal, love the man, he's from Turkey, his name is Attila Tuna. Mr. Tuna owns, he testified he didn't own OFT, that his brother did, but he did testify that he managed it. Well, the court found as a finding of fact that he actually did own both. That fact hasn't been challenged on appeal, so I think that fact is probably controlling. But he clearly managed the company, and if you look at the exhibits, I put in our contract, or OFT's contract with Rush Steel, which is exhibit number 5, and Mr. Tuna signed that contract on behalf of OFT.
So it's kind of like you're using alter ego or sham contractor sort of offensively rather than defensively.
Well, yes, although the statute doesn't make a difference. It doesn't make a distinction, and they pled it as being true in their pleadings. I think that's a judicial admission, and so the reason why that's important, obviously, is it elevates the contract to an original contract. The only reason why the court said you're liable for the full amount here is because the court, even though there was no evidence of what our contract amount was with OFT or how many payments we made to OFT, when we made those payments, how much we retained, any of that stuff, the court said, well, he testified it cost about $4 million to build this building, so he should have withheld 10% of that $400,000. And that only applies if the contract you look at for determining our retainage obligations and trapping is our contract with OFT. But if you use the sham contractor doctrine, you would just use the contract with Rush Steel, between OFT and Rush Steel, and that really is the contract that should be used here.
Okay, last question then, just a comment on offset.
On offset? Yeah. So it's interesting. When I was looking at that issue, the way that the statute deals with offset is under the retainage statute, you're only required to retain what you're required to retain under the contract that you have with the contractor. Under our contract with Rush Steel, we were not required to retain amounts that we used to fix its work. And so we were allowed to use the contract balance to finish and complete its work. So, and then the case law supports this as well. The case law says that basically, if you terminate a contract because of non-performance or because the work wasn't done, then the retainage amount also decreases with that. And when that happens, then you just look to the value of the work that was actually provided. And the statute says that too. And so the only evidence on the value of the work that was actually provided was $35,000.
Thank you very much.
You're welcome.
All right, so we'll give, is it 5 minutes to the appellee?
Good afternoon. May it please the court, Misty HATAWAY-CONE here on behalf of Service Steel. I'm going to try to move through in the same order in which the questions, I did take pretty good notes, and the questions in which were directed to appellant. I do want to remind the court of a few key things. The judgment that was awarded was, or that was entered rather, was for $177,581.87 with 18% post-judgment interest attached. That 18% post-judgment interest does in fact come from the contract between Rush Steel, Ipsum, and my client, Service Steel. When I was sitting here taking notes...
Can you explain that?
Sure. I absolutely can jump to that. So the agreement that my clients operated under was the agreement that with Mr. Gonzalez's company, which the invoices were to, which Justice Doki will acknowledge, were to Rush Steel / Ipsum. Okay, the invoice was a known issue, that the relationship between Rush Steel and Ipsum was known. In fact, with all due respect, the emails that you referred to, Justice Doki, actually were before the lien was sent. So before the affidavit asserting the lien was ever sent to ASTRA Ventures, there were communications from ASTRA Ventures following up on the Ipsum invoices. And so this idea that somehow, post fact, that ASTRA Ventures learned of this Ipsum name, that's contrary to the evidence in the record. But the contract, Justice Gira, that is at issue in this case is not the contract between ASTRA Ventures and OFT or OFT and Rush Steel, the contract that my clients have a right to move under, the only contract that my clients have a right to move under, is the lien rights they have by virtue of the services that they provided to Rush Steel that benefited the owner, ASTRA Ventures. And in that contract, Your Honor, it preserves a right of 18% per annum for interest. And so, Your Honor, that is where that number comes from. And I again respectfully disagree with opposing counsel. I think the case law respects the right for this interest to be governed by that contract. And we briefed this issue, Your Honor, in our brief, but it's the Patriot case. And the Patriot case is actually a 2021 pet denied decision where we look at the contract. And Justice Gunn is absolutely correct. There are three sources that we can look at the interest on. We can look at enabling statutes, we can look at CPRC, but we can look at these other areas. And the Patriot, which was decided just 4 years ago here in Houston, it makes very clear in a pet denied decision that we can be governed by the contract at issue. And that case, unlike the cases that were cited by appellant in their briefing, was a lien case. And so, Your Honor, that's where we get the 18% from. That ties into, Your Honor, this whole contract argument with the offset argument that was raised. I don't want to put the cart before the horse because I do feel that appellant is doing that a bit. Appellant presumes in its argument that we even look at the issues with offset. We even look at any of these issues that were not specifically denied, and I am going to get into that. But because of the relationship between this 18% interest being guided by the contract with Rush Steel and my client, I want to talk about the position being taken by appellant. The position being taken by appellant is asking this court to recognize, for the first time in Texas law, by the way, that the negligence or malfeasance or tortious actions upstream from the lien holder can be used to offset and to degrade the value of the services that were provided. And let's think like philosophically with that position. What this position is saying is that an innocent provider of supplies or services to Rush Steel, who performed services in compliance with its contract with Rush Steel, who provided services that in fact benefited OFT and benefited ASTRA and its beautiful medical facility, can be cut down, can be minimized and diminished by the tortious conduct of someone else. And Your Honor, that is not a position that's recognized in the statutes, and that is not a position that's recognized in Texas law. And so that is asking this court to create new law and to carve out a right in Chapter 53 that does not exist. And Your Honor, we don't believe that when you look at the cases that the appellant relied upon, that it is procedurally proper in this instance to provide that offset. And we briefed that in our briefing. But I do want to go back to the waiver issue because I think right out of the gate, y'all hit the question of the affirmative defenses in paragraphs 14 to 17 in appellant/defendant's answer and whether or not that was sufficient to specifically deny. And I did not put together a supplemental brief, but I did take some notes that I want to use if that's okay. When you look at the answer in paragraph 14, which is Clerk's Records, Volume 1 at 17, paragraph 14 basically says that Rush Steel had no relationship with Ipsum Building Supplies. Your Honors, none of that has anything to do with a specific denial of compliance with Chapter 53.
What page was that? I'm sorry, in the record.
Oh, it's page 17 of the first volume, Your Honor.
Yeah, got it.
When you look at paragraph 15 of the affirmative defenses in ASTRA Ventures' answer, it effectively says that Ipsum Building Supplies was not a subcontractor on the project. Okay? That also is not a specific denial of non-compliance with Chapter 53. When we look at paragraph 16, it effectively says Ipsum Building Supplies was not a subcontractor or a subcontractor of a subcontractor, so the lien is invalid. And so, Your Honor, when we look at that, that likewise is not a specific denial of compliance with any provision of Chapter 53. I'm going to walk through those provisions in just 1 minute. I'd like to give the characterization of that last final paragraph, Your Honor. Paragraph 17 of the affirmative defenses effectively states that Ipsum Building Supplies was unknown to the owner. So when we look at that's what those paragraphs in the answer are, let's look at what was required to to meet the minimum requirements for Chapter 53. And we briefed this, Your Honor, in our brief. And you'll see when we walk through each of the provisions, this is on page 27 of my brief, but it's Texas Property Code 53.054. This is what must be specifically denied, and it was not. In none of those 4 paragraphs we just looked at did ASTRA Ventures specifically deny the last known address of the original contractor. It did not specifically deny the legal sufficiency or the identification of the property sought to be charged with the lien. It did not specifically deny the claimant's name, mailing address, and if different, the physical address. It did not specifically deny any of the provisions, specifically the general statement of the kind of work done and materials furnished for the claimant. So when you walk through 53.054A, none of these affirmative defenses relate to what's required in that affidavit of lien. And Your Honor, let's look at the next issue, which was the broad general denial that all conditions precedent had been met, right? The catch-all, which most lawyers include in their answers. When you look at that, case law makes clear that that actually is insufficient. And so we likewise briefed this issue, Your Honor. And there is a specific case on point that says that a simple general denial that all conditions precedent is insufficient to point the movement into what the defect is. And so this is the Trust World decision, Your Honor, by the Beaumont Court of Appeals that likewise was PET denied. And the reasoning there, Your Honor, and I put this in my brief at page 12, the broad denial in their answers, this is the Beaumont Court of Appeals, that appellants failed to properly perfect its liens pursuant to the Texas Property Code, failed to specifically state in what way the liens were not properly perfected. And that is why the broad denial was insufficient. So, Your Honor,
how do you respond to the argument that this was sort of tried by consent?
Well, Your Honor, we believe it wasn't tried by consent because consistently we have pointed out these defects. We pointed out that the problems, and what I find interesting is that the party who is being accused of waiver is arguing that the other side waived. And so when you look at the record and you look at the issues that are being made, I don't think that the record provides evidence to support that waiver. I do want to also point out, though, Your Honor, that on a number of issues that were raised in the appellant's brief as well as in their time here before the court so far, they're raising points that were not properly preserved in findings of fact. And so when you look, for example, at this sham contractor issue, there is no finding, nor was a finding requested by the appellant of a finding of sham contractor. And yet there is argument here today, there is argument in the briefs about whether or not ASTRA Ventures should be considered a sham contractor so that it could drop a level down and reap the benefits of a general contractor under Chapter 53 rather than the owner. And so when you look at the number of waivers that have occurred in this case, the waivers are on this side of the room and not here. Service Steel has been consistent in its position that it provided these services, it provided this steel to Rush Steel on the project. There has been no denial that the steel and services that my client provided were in fact used on the project. That would be another specific denial that would need to be made. It was not made.
Was it not argued, I guess, at some point that maybe some of the steel was used for one of the projects and some used for a different project?
Well, Your Honor, even if that were the case, which it is not, case law is clear that that alone is insufficient to find the lien defective. We also briefed that issue, Justice Guerra, because you can look, there's a case directly on point. It is Brick and Tile versus Parker. Literally held that a mechanic's lien cannot be defeated by proof that the buyer used part of the material on other construction. So even if that were the case, which Service Steel is not saying was the case, that is insufficient to find the lien defective. So, Your Honor, let's look at, I'm going to try to go through the other points that you asked us to look at. Justice Gunn, you raised the impact of the LTF real estate decision. I did have to read that one, I'm not going to lie. We read, you're not going to be a bit surprised, we read LTF very differently from opposing counsel and appellant in this case. When we read LTF, we see that there were a number of defects in the underlying lien in LTF that simply do not exist here. For example, in LTF, the lien affidavit did not include a statement of each month in which work was done, as required under Chapter 53. The lien affidavit at LTF likewise did not identify the name and last known address of the person to whom the claimant furnished the material or labor. That is not the case here with the service deal affidavit of lien. Third, the lien in LTF likewise did not provide a statement identifying the date each notice of claim was sent to the owner and the method in which it was sent. And so when you look at LTF, just right out of the gate, Justice Gunn, you see that there are defects in the lien affidavit at LTF that did not exist here. And yet appellant is taking the position, a rather broad position, that a misnomer in that case is the reason why the court found error in the foreclosure. But Your Honor, we briefed this issue. The use of assumed names is proper and is used throughout areas of Texas law, including liens. And so there is no issue whatsoever with the fact that Service Deal provided notice consistent with this contract and consistent with the information and job sheet that was completed for this project, and consistent with the practice with this particular client for Rush Steel, that we completed in accordance with that relationship. And it did, in fact, put ASTRA Ventures on notice. But ASTRA Ventures, as we talked about in a minute ago, Justice Stokefield, was already on notice of the fact that Service Deal was providing this work and that Service Deal was providing it to Ipsen.
Question about that. Since Service Deal seems to have been aware that Rush Deal was a DBA, why not put Rush Deal DBA Ipsen on the lien and save a lot of effort here by covering bases from the beginning?
Well, I would say hindsight is always 20/20. I think dang near every single case that gets into litigation, hindsight is 20/20. Maybe I should have turned left on that street, or maybe I should have put this oral agreement into writing. At the end of the day, we are with the record that we have. And what this court's duty is to do, and what my job is to provide you, is that we have substantially complied with the requirements of Chapter 53. And so, Your Honor, when you look at the invoices, there is testimony and evidence in the record that the invoices were submitted. Basically, they changed dependent upon who the ordering person was at Rush Steel. Mr. Gonzalez, even himself, there is evidence that he used different names himself. He didn't even know which name they were operating under this agreement for this project. And so we have some misnomer issues. Actually, it isn't misnomer. We have assumed name issues by Rush Steel. And our work was consistent with what Rush Steel was accepting and what it received. In addition, by using the name Ipsen and by using the name that ASTRA Ventures was well aware of, they were well aware of and have not been prejudiced in any way or blindsided in any way by the affidavit of lien and the substantial compliance that my clients have done with the statute. The next issue that Your Honors asked us to look at.
Sham contractor.
I was going to go in order. It might be. It is, in fact. Let's turn to sham contractor, Your Honor. So, Justice Gunn, you recognize this right out of the gate, that this is an instance where we have a property owner trying to use the sham contractor doctrine affirmatively as a sword, rather than what the sham contractor provision was intended to do, which was to protect the potential lien holder and to protect the materialmen and service members that have provided work. And so we are, again, I'm not trying to make necessarily a policy argument, but the position that appellant is asking this court to make is a first of its kind. It is asking the court to allow an instance where you're using it affirmatively by the property owner rather than, the general contractor. And so let's look, however, at the requirements for a sham contractor. And this is found in Chapter 53.056. And so the sham contractor affidavit looks at a number of factors. And so the ownership of voting stock, the interlocking directorships, or otherwise provides as follows. So A person who labors, especially fabricates materials, or furnishes labor or materials under a direct contractual relationship with another person is considered to be in direct contractual relationship with the owner and has a lien as an original contractor if 1. The owner contracted with the other person for construction or repair of a house, building, or improvements, and the owner can effectively control that person through ownership of voting stock, interlocking directorships, or otherwise. There was no evidence presented in the trial of each of that. There is a commonality of the brothers, right? But Your Honors, when we look at, in this day and time, particularly in the building and construction industry, there is often commonality of owners. There has to be more under the statute. When you look at A2, it says the owner contracted with the other person for the construction or repair of a house, building, or improvement, and the other person can effectively control the owner through ownership or voting stock, interlocking directorships, or otherwise. There was no evidence of control that was provided to the trial court.
The appellant made a point about a fact finding. We don't have them, they're not numbered, but saying there's a fact finding, essentially finding, I'm going to call it fusion or joint ownership. I don't know the right jargon. Do you know what I'm talking about?
I do, Your Honor. There was a fact finding of ownership, but there wasn't the fact finding of the other indicia that are required to establish the sham contractor. And in fact, when you look at the record, there was not a request for it either. And so while there may have at one time been a pleading, this court must look to the findings of facts that were entered, and for preservation purposes, must look to the proposed and amended findings that were offered, and to see whether or not this issue was preserved, and it was not. It was simply not preserved.
Understand the argument. Okay.
And so, Your Honor, I've also asked the court to look at First National Bank versus Whirlpool when we are looking at the sham contractor doctrine. And here, when you look at the testimony, we see that the testimony at trial does not meet the requirements of the Whirlpool case. And I fully recognize that Whirlpool is an old case. It is 51 years old. But at the end of the day, it is one of the no, Justice Scott, I'm not
that old.
I'm not making fun at all.
That's fairly young.
I just turned 49. I am not making at all a comment about the age of anyone in this room. But what I am saying is it stands true and is still good law today. And it has consistently been cited and relied upon by a number of intermediate courts of appeals. But let's look at the testimony, Your Honor, with regard to control and ownership. And so the testimony at trial was purely limited to who managed each company and who owned the companies. There was no evidence presented at trial of who managed this project. And so there's a real discord, Justices, of the testimony at trial regarding ownership of the companies versus who oversaw, managed, supervised this contract and this project. In addition, there was no evidence presented that could even identify the directors of either company. So we can't look at any kind of commonality of the directors of the company. We just have the one finding for ownership. And then finally, when you look at Whirlpool, it appears that those are the two key factors that the court looked at: the control of the subject project or subject contract, and then kind of the director commonality.
What's the name of that case?
It is First National Bank versus Whirlpool.
I got it.
I can give you the site if you need it, Your Honor.
No, I got it now.
Yeah. And so when we look at the guidance that we have on this issue from the Texas Supreme Court, we see that the evidence to meet that guidance was not provided to the trial court. And again, the issue was waived and not properly preserved because there was no request for a finding. There was some offering of argument with regard to the retainage, Your Honor. It does tie into that contract issue that I started out of the gate with. Appellant is taking the position that they are only required, in this instance, to retain $11,000. You've probably heard it 3 or 4 times during their arguments. But when we look at the statute, at what the required retainage is, there are 3 definitions that are defined in the Texas Property Code that we have to look at. We look at contract price, which means the cost to the owner for any part of construction or repair performed under the original contract. We look at original contract, which means an agreement to which an owner is a party directly or by implication of law. And then we look at original contractor, which means a person contracting with an owner either directly or through an owner's agent. Those are the key definitions that guide us at examining 53.101, which is the required retainage provision. And there it says, during the progress of work under an original contract, which is that agreement by the owner, ASTRA, to a party, they must retain, to cover a mechanics lien for a period of 30 days, 10% of the contract price. And so, Your Honor, because the subparagraph 53.101A1 relates to contract price, our interpretation and the interpretation of countless other intermediate courts of appeals, which we have briefed, is that contract price language of 53.101A1 relates to the 10% retainage of the original contract. And that would make sense, Your Honor, right? Because if not, you would never withhold enough of the potential retainage to cover all of the potential liens that may come out on a project.
So what's the relation between, same question I asked your friend on the other side, the relation between the retainage argument and the traffic statute argument? Do they both have to be reached?
They don't both have to be reached. I think that they are separate independent bases to find errors by ASTRA Ventures in this instance. I do find it interesting when you look at the testimony from ASTRA Ventures in trial. The testimony is basically, yeah, we paid them. I mean, they're going to get paid anyway. And so we believe they prematurely paid the general contractor, failing to adhere to the required retainage to pay for all of the remaining liens that may be out there. The record is not clear of what other liens may exist with regard to this project, but that's the purpose of the retainage, is to cover any potential materialments or other liens that may pop up in that 30 days. And so this interpretation that you only have to withhold 10% of the sub-sub agreement, that would turn the industry on its head, Your Honors, because in that instance, we would be chasing, we as the sub of a sub, would be chasing in perpetuity. And that's the whole point of what the statute was there. It was to protect innocent subs of subs who furnished work of which the owner, the general contractor, received the benefit of. And here, the owner absolutely received the benefit of my client's work. The owner absolutely now has a beautiful medical center that it is used. The owner knew that my client was providing services to Rush Steel via Ipsum. And now, years later, unhappy no doubt with Rush Steel's work, of which my clients have nothing to do with, they now are refusing to pay. And refusing to pay invoices that 2 weeks before the affidavit was filed, they knew were outstanding. And
Could
so
you talk on the interest issue in the interest of time, since appellant aired it out? What's your side of the story?
Happy to do it, Your Honor. And so I'm going to direct the court to, yet again, another old case, and I'm not pointing out my age or Justice Gunn's, but when we look at Hayek versus Western Steel, it's a Texas Supreme Court case from 1972, and there we have lien claimants in Hayek that were two material suppliers, including actually a structural steel supply company and a concrete company. And they sold materials for the construction of homes. And at the end of the day, there was an award, when the lien was foreclosed upon for non-payment, the trial court awarded the pre-judgment, or rather the post-judgment interest that was spelled out in the contract. And so because post-judgment interest under the statute is a direct award, and because under the Patriot decision we talked about a bit earlier, you can look to the contract in this instance, and that's again a 2021 Pet Denied case, it's proper for the trial court to have awarded 18% interest.
On what? Is it on a statutory basis or on a common law basis?
On the common law basis, and that's what the Patriot decision from 2021 recognized, is that it's still proper. You are not required to be limited to the enabling statute. Common law still exists, and the ability to recover that interest on a common law basis is still proper. And again, Patriot was a lien case where we looked at an 18% lien or interest that was accrued and awarded on a lien as a direct damage award. And so when you look at the similarities and commonalities between this exact case and the lien affidavit and the underlying contract in the Patriot decision, you're going to find significant commonality.
So my last question is not about the merits, but just about the economics, because I'm having a hard time getting my head around where we are. There may not be an answer to this question, but I mean, I'm looking at two good lawyers, and if you spend 100 hours at whatever market rate is on this $83,000 fight, I don't understand how we're here and it hasn't gone away.
Well,
that's not a specific question, but we're not going to have the opinion out tomorrow. So when you walk out of here, maybe talk about finding a way to work it out. So that's not a question.
Yeah.
It's just an observation. And we want to be helpful. We'll grade the papers, whatever you send us. But it's an awful lot of paper and an awful lot of work over not an awful lot of money, and with very good lawyers.
Justice Gunn, I'm gonna take a point of privilege for a minute. I've had the pleasure of knowing and working with Paul PILIBOSIAN for over 20 years. We worked at a firm together. He's a great lawyer.
In that case, I've heard enough. You don't have to go. It's okay.
But I do want to point out that we believe that when you look at the standard of review, that the appellant has failed to meet its burden under that standard of review, and that Judge Bridges was properly entered the findings of fact and the judgment that he entered. And then when you look at the record, the findings of fact are supported by legally sufficient evidence. And then in addition, the judgment now is a little more than $83,000. It's $177,581. My client and I would have loved for Judge Bridges to have awarded attorney's fees. But at the end of the day, we do have 18% interest on that amount that is continuing to accrue. And so until this is resolved and paid,
The face value of the judgment is climbing.
Yes, Your Honor.
I understand.
And so I wish I could tell the court whether or not this matter was properly or even attempted to be mediated. But what I know is what I know from the record, and that is that the appellant has failed to meet its burden to show any right to recover before this court. Legally sufficient evidence supports the findings that were entered. The other issues that are raised by the appellant were not properly preserved, and so we ask the court to affirm the trial court. Thank you very much.
Thank you.
That was a long 25 minutes.
I'm not getting any younger up here.
I want to start with this prejudgment interest. The opposing side, Misty cited, sorry, Ms. Cone, cited the Patriot case. The reason why the court, this court, not these justices, but this court awarded prejudgment interest in that case, that was a bond claim. And the court looked to the terms of the bond to determine that the bonding company had specifically agreed to pay amounts due to material men under their contracts with subcontractors. That was the reason. It wasn't saying that no material man who files a lien can get prejudgment interest against, or contractual interest against a non-privity to the contract. That was a contractual basis for the bonding company to be liable for that interest, and we briefed that in our brief. It's interesting, Ms. Cone said that there were no findings of sham contractor. Well, there were several findings that there was not a legal finding of sham contractor, but you don't need a legal finding, right? You just need the factual findings. And the factual finding was that Mr. Tuna owned both OFT and ASTRA Ventures. There was a factual finding that they had the same exact address. And Ms. Cone talked about, well, there was nothing about directors, common directors. Well, they're LLCs. They don't have directors. Mr. Tuna signed the contract for OFT with Rush Steel as manager of OFT. And we cited a case in our brief where it's Shaw versus, well, I can't read my own writing, but McPhail Electric. And it's 544 Southwest 2D 492 out of Dallas. Older case, 1976, refused. But in that case, the court found that just because sham contractor was sufficiently found when the only evidence was that the owner signed the contract on behalf of the general contractor with the subcontractor. That elevated that contract to an original contract under the statute, under the sham contract. And that's exactly what we have here. We have the owner signing the contract for OFT, who is also the owner of ASTRA. So we believe that is sufficient evidence. And think about it, why else were those findings in there? And there's so much back history to this that I wasn't able to get into, but the notice letters that were sent, they weren't sent to ASTRA Ventures. Undisputed, weren't sent. They were sent to OFT, who didn't get them, and a company called Enclave Property Management. If they didn't send notices to the right people, if it's not a sham contract, why else are those findings in there? They needed those findings in there to show, well, look, they're all the same, right? OFT is the same as the owner. So they're using it as a sword and a shield in this case. They're using it to say, well, our notice letters are okay, but it doesn't affect how we calculate how much you owe us if these doctrines apply, and that's not fair. Otherwise, we would say, okay, well, then their notices weren't proper. And that's the other thing I really wanted to hit with you all, Your Honor, excuse me, I do that a lot. We talked about, and again, Ms. Cone did a very good job of pointing out the deficiencies in our answer, but as was the case with their brief, they just completely skip over the case law that talks about other pleadings, right? And if you look at Exhibit 3, which is actually, my client filed a no evidence summary judgment, believe it or not, and one of the basis was that they didn't provide timely notice under the statute, or proper notice. And they specifically identify the provision of the statute that requires the notice, and they say 53.056A2 requires that each notice must identify the party with whom claimant contracted if different from the original contractor. And it points out that they identified Ipsum Building Supplies. Nowhere do they say anything about Rush Steel Fabrication LLC. And so they say that their claim is not proper because of that. And then the next exhibit is Exhibit 4, and for all the things that I think the trial attorney failed to do in this case, it did one thing that was a little unusual that I think might actually be some benefit, is he filed their disclosures with the court. And he filed them with more than 7 days out from the trial. And in the disclosures, he's even more specific. And this is Exhibit 4, page 809. And it says that the statutorily required notices, which are conditions precedent to filing an affidavit of lien or asserting a materialman's lien cause of action, named only Ipsum, not Rush Steel Fabrication LLC. Defendants thus receive no valid notice as required by statute. And then he says, the affidavit of lien filed by plaintiff likewise erred by naming Ipsum, not Rush Steel Fabrication LLC. Plaintiff's cause is invalidly based upon an erroneous affidavit. A valid and legally sufficient affidavit is required by statute. And so, and he even talks about set-offs. Plaintiff has falsely denied in its affidavit and lien and petition that any set-offs are due, and to the extent any materials may have been used in defendant's projects, which defendants deny. Plaintiffs have failed to account for, credit, or offset advances or payments made to the party defendants dealt with, not Ipsum, and or for materials never delivered to the project or were rejected. Again, this is not a case where my client hid behind the law. They put all these defenses out there. It might not have been in their answer, but it was in filings that were received by the court, which is sufficient to comply with the Texas Rules of Civil Procedure 54.
I'm pretty sympathetic to that argument. It looks to me like that is kind of what you fought about. So I get it. Can you respond on the interest point? Because it sounds like the 6 versus the 18 does add up here.
And I tried to at the beginning. That's it.
Yeah.
I think they're relying only on that Patriot case. That is the case they relied on in trial. That is the case they're relying on here.
You say it's a bond case.
Not just saying. I mean,
Right.
it is. I mean, if you read it carefully, that's exactly what it is. And so it's just not the case here, and it just flies in the face of common sense. Why would we be liable on a debt that we're not liable for, right? We're not liable under this underlying debt. The only reason why we're liable for anything is because the statute makes us liable for funds we don't track. And that was the other point I wanted to hit with you, Justice Gunn, is you mentioned the point again. Is there a distinction? Is it a distinction without a difference between retainage and trapping? We're only personally liable for failure to trap. We're not personally liable for retainage. Okay? And so there was no evidence of trial about when we made any payments to OFT, how much our contract was for, when those payments were made. There was no evidence of any failure to trap. If anything, they could argue, well, you didn't retain. Well, the testimony was we did retain, although there was no evidence about when we did or when payments were made. So the evidence isn't there if you go by the original contract. But the reason why the distinction is important is because there was a judgment against us for $83,000, and if you just go by the trapping statute, that judgment at most should be $11,387. I believe is the
Thank you both sides for your arguments today. The case is submitted. We are adjourned.
All rise.